So, folks, Kirk Hogan, all right, and of course Maurice Christian Garcia, right in the background there on his cell phone, and everybody is on their cell phone. I'm usually guilty of always being on my cell phone as well. So,
you know how it goes.
Yes,
that's right.
So yesterday we were talking about. Let me read this. We were talking about these 10 persons connected to the alleged fraudulent payment of $22.5 million in salaries at the San Juan Laventille Regional Corporation. I think what my question was, I've seen some people listed were actually, they are held with 100 counts of money laundering, some of them 69 counts, some of them 95 counts. And I'm like, what does that mean, sir?
Right. Well, generally speaking, money laundering is where you channel the proceeds of crime through a legitimate organization who then attempts to put that money into the legitimate financial system.
So it will have to be drugs.
So it's not necessarily only drugs. It's the proceeds of any crime, any criminal activity. So if you're into a large car theft ring, which I understand is now I think our second largest criminal export.
Really?
Yeah, car theft ring. Second to drugs, yeah.
Wow.
Then if the proceeds of that criminal activity are channeled through a legitimate business, much like your own, and you use those funds for the purposes of creating legitimate funds, then you're money laundering. And that's governed by the Proceeds of Crime Act in Trinidad. So, seems as though what these individuals have been credited with is in fact the act of trying to channel the proceeds of crime through a legitimate organization, the organization in which they worked.
Right.
Of course, paying it out as salaries. Now, I don't have all the details because I was taken by surprise by the entire thing, and all the counts were still being read up until the last time I think I had contact with the matter. So I can't say that I'm as familiar with it as I should be. But as time goes by,
yeah, we'll always hear a drip of information here and there, and I don't know, these people just look like hard-working people.
Like regular
working citizens, normal citizens who maybe took a bite at an opportunity. That is how it looks from just looking at them.
Well, I'll tell you, anybody's mugshot will look like a working stiffer, no matter how rich you are.
Because Nizam Ali, he looks like he has a landscape kind of business.
I have no idea.
He just go and clean yard, like a yard boy.
Well, I wouldn't be accused of profiling. I don't want to be accused of profiling.
Oh Lord.
No, but seriously, no, I get what you're saying.
They just look like average citizens, like the people on the ground. I am yet to see some kind of officials be a part of this past.
Well, I honestly don't know what their status was and what the individual component each one of these guys played in the ring.
And at
the end of the day, we still have a situation where this is a country that we accept the presumption of innocence, so innocence until proven guilty. But I could tell you as a fact, the challenge now is that in prosecuting this offense, we are not likely to see the tail end of this offense for many years to come unless something drastic happens. Because
really?
857 counts, there's no way that matter is going to pass through our courts in under 15 years.
You serious?
No, there's not likely to be any resolution to this matter in 15 years.
That is what that means?
Easily.
Why is that? Why is that though?
Well, first of all, the number of counts. Right? And I always tend to think that while there's an offense for every count, there need not be a charge for an offense for every count, because you have to consider the factors. What is your goal? Is your goal to actually bring justice to the situation, or is your goal to prove to the public that we're doing something? 857 counts, while they may all be justified, may be excessive, because at the end of the day, the challenge now becomes prosecuting those offenses. How do you prosecute 857 counts in one trial? Because it's likely to be a joint trial. This is going to be an extremely long an extremely drawn-out trial. And I can tell you from a defense counsel perspective, this is, how should I put it, a miracle of a trial if you're going to go into something like that, because you know this is going to last forever. And secondly, if it ever does get before a jury, the possibility of a jury sitting down and really getting into these kinds of matters in detail, oh my goodness. So this is likely to be a matter that may be a judge only, and we may have to appoint a specialist judge to deal with this, because you may have need of a judge who has some special corporate capabilities, some special corporate experience. So I suspect that if this were to go all the way through our system, this may be one of those cases that may force us to give us a real proper rethink about what we're doing about crime in this country and dealing with the situation. I think 857 counts in one case of this magnitude seems unprecedented.
And it's not just one person. So is it that everyone has to be tried independently, or is it a collective case?
By the Constitution, you are entitled to have your case tried individually. However, for ease of reference, 9 times out of 10 trials usually dealt with jointly, right? Because the state may well object to having you tried separately, because it requires them to then, of course, lead the evidence on each count, on each person individually. I don't know the individual roles. I don't know the capacities of each individual. I don't know what the charges are against each individual. So I don't know how the connections link up. But more likely than not, the prosecution is going to want to try all the matters together, because all the evidence would only be required to be led once or twice, as opposed to having to lead evidence on each individual separately, which may require evidence being repeated. So more likely than not, the state, of course, is going to want to deal with it as one matter. And hence the problem begins.
Okay.
So we are now going to have a situation where you have how many accused so far?
10.
10 accused.
Missing one for football
10
team.
accused. Maybe a handful of prosecutors. A battery of attorneys for each accused. At least 2 ultimately on each accused.
So that's 20 lawyers.
Talking maybe 20 defense counsel.
Wow.
Right? Wow. We can start. Let's start conservatively. Let's start with 1 per accused. That's at least 10. You're going to likely expect to have senior attorneys involved in this matter, which means they are going to have junior attorneys with them. So that is where the additional attorney usually comes from. So you may find at any point in time in this matter, there may be 10 to 15 attorneys, all right, on rotation, and as many as 20 on rotation in defense, right? Whether it be by way of legal aid or whether it be by way of
this is not a legal aid case.
Well,
I don't think, because if it's a legal aid case, then we really think they really take that $22 million.
Listen. Whether they took it or not, our legal aid system in Trinidad affords anyone the opportunity to acquire legal aid. They don't bother with what we call the means test. The means test is to determine what is the means of the person and whether they should be a drain on the state's resources
or not.
Okay.
We don't apply the means test anymore. They do it for civil matters, which is kind of ironic.
Really?
They do it for civil matters, but they don't do it for criminal matters anymore. It is in fact in place, but it's never used. So anyone who applies for legal aid gets it.
Wow.
I don't know if people recall Abu Bakr had the audacity to ask for legal aid and would have been granted legal aid, but for I think the matter being dealt with and disposed of in a different manner.
Okay.
Right?
Okay.
But he was legally entitled to ask for it.
Okay.
As to whether he should be granted, it's a different story. Right or wrong, not a legal issue for us, but the question is, should he have been granted? Did he qualify? That's a different story.
Right.
Yeah.
But as I said, we don't apply the means test, so generally anybody who wants a legal aid representative can get one. And most of the attorneys who operate in Trinidad and Tobago on the criminal side, as a criminal bench or at the criminal bar, are on the legal aid board, because most of the matters go through legal aid now.
Wow.
It's shot us in the foot, quite frankly, and we're paying the price for it. Well,
how is that?
I always tell people, you hear your mother used to tell her, me and her court closed.
Yeah.
You understand? Me and her money to pay lawyer. All right. But now that you don't have to worry about court close and money to pay lawyer because legal aid providing it for you, there's less consequence.
Court closed too?
Court close was expensive. No, but there was the informal approach was that having to pay an attorney to represent you in a criminal matter was part of the consequence of being associated, not necessarily being found guilty, but being associated with criminal activity.
Yes.
So even if you're lying with your boys and them get in trouble,
And
you get in trouble too.
Right.
And your parents tell you, we ain't have money to pay lawyer or we ain't have court close. It was meant to send a signal that lawyers are expensive. Trouble is expensive.
Out of trouble, yeah.
Keep
Correct.
yourself out of trouble.
That's right. So now when every Tom, Dick and Harry can walk in and get legal aid, that's part of our informal approach has fallen away. Some of our informal safeguards have now fallen away. So nobody's studying, well, they understand that anymore because, hey, you don't have to pay a lawyer anymore because, hey, tell the court you don't have one, they'll appoint one for you. And I'm telling you, we're not talking about, it's not like the states where they have this approach to defense counsel who are appointed by the state that they're not competent. Most of our attorneys are very competent in Trinidad.
Okay.
So that being said, it means that you get competent representation, no money, no consequence. So at best, what you do is sit in jail and wait until you get bail if you're getting it.
If you're getting it.
And in most cases, you are legally entitled to bail, so you get your bail. Until
Eventually.
at some point, eventually.
And if you could pay it, you pay it. If you can't pay it,
you wait until the court is willing to vary it. So,
wow.
Ultimately, and you see, one we don't understand is that when we break down these informal aspects of our society, the formal aspects suffer and we pay the price in it. So we pay the price in the formal system because of an informal approach that we took that, hey, all right, it's okay. Everyone could get legal aid because, hey, understand? So I don't know what the circumstances are, but I strongly suspect they may not want to go by way of legal aid. Some of them may, who knows? But I strongly suspect that initially there may be an approach to a few attorneys who will represent them, and thereafter, when resources are finally depleted,
then with all these counts, so most likely this case is most likely is something that is going to be happening for a number of years, just like the coup.
No, not the coup. People ignore it, but think about the airport inquiry.
Yes.
That's still going on, though.
That's still at the preliminary inquiry stage.
No, are you serious?
Wait.
I don't believe that.
That didn't start like 10 years ago?
10...
That's right.
10 years ago?
Yeah, it was about 10 or 11 years ago. That's when we were at
I can't recall if they had any real progress this year in terms of a decision, but it was still at the preliminary inquiry stage as of this year. That matter has not has not moved beyond the magistrate's court.
Wow.
So, because of the number of different applications that came in between and the number of different decisions that had to be made, the number of charges. So, if that takes that long, and these men had the resources, financial resources to fight that battle, and they did. A lot of them probably depleted the resources fighting that battle.
Wow.
A lot of the lawyers probably didn't make much money fighting that battle because they were stuck on their retainer. But consider the airport inquiry, and the charges were significantly less. And I suspect it was likely to be less complicated than the scheme that these guys ran, if they in fact were involved in the scheme, or that, let's should say, the scheme that's been alleged that they ran. So if that took this long, imagine what it's going to be like for 857 counts to run through our courts. I suspect there are going to be a few courts that may be inoperative. There are at least 2 magistrates' courts that's likely to be inoperative because of this, if this matter really were to proceed in the way I expect.
But if it is to be executed in the way a situation like this would normally be executed, is there a possibility that the case can get thrown out?
What was the possibility? Given the number of charges, it seems likely that some of these charges are going to stick. Right? I mean, it's just a numbers game at this point. As I say, I have no real information, but just on the mere numbers that are thrown at these guys, the odds are something will stick. So the problem, of course, is we don't know what.
That the burden of proof is on the state.
Always. There's a presumption of innocence on each one of the persons who've been charged. Fact is, they're innocent until proven guilty, and the state's burden is to prove that guilt. Right? So at the end of the day, it's the state's job to set out, and this first stage is only going to require the state to determine whether there's sufficient evidence for for the matters to go forward.
To
Now, I don't know if any of the matters are laid summarily, meaning that they can be determined at the magistrate court at a trial.
Right.
But I suspect most of these matters
Records
are
have a way
indictable
of
matters.
records have a way of disappearing. Huh?
Well, I don't know. I don't know about the institution that they're attached to. That might well be the case. But if the state has already laid the charge, I would expect that the investigation has been done and there's sufficient evidence within the hands of the state to justify the charges that they've laid. So, if they're now going after the fact to gather more information, that might be a problem. That might be a different issue.
Diana says she's not hearing.
Really?
Check the volume on your phone.
I checked and it was up for me.
Yeah, I don't know how to check it on.
Oh, she says she's on a different device now.
Oh, okay.
Let's just pick it up.
Hi Nikita, how are you? Roger Gill, what's up, my brother?
Roger Gill from Gill Tech Services.
What's up?
He's doing lighting and stuff for events.
Is this Sadira? How are you? Also Natasha Phillip. Just Francis is definitely on. I feeling as though I'm reading the same thing from yesterday, boy.
Natalie is
Yeah,
asking.
I'm going to tell you, I have a loyal crew, that's good.
Is asking if you can send the link with the article.
Who?
The article. Is it Guardian?
The Guardian,
Right, the
yeah.
article,
I think
yeah.
Guardian printed that.
I think I'll be doing some reading this weekend on it. Oh, I even have the section on it.
Yeah.
Can I pull it up? Yeah.
Yep.
So, I actually have the section on the Proceeds of Crime Act, right?
Right.
Okay.
So, if we're talking about money laundering, it says a person who knows or has reasonable grounds to suspect that property is criminal property and who, A, engages directly or indirectly in a transaction that involves that criminal property, or B, receives, possesses, conceals, disposes of, disguises, transfers, brings into, or sends out of Trinidad and Tobago that criminal property, or C, converts, transfers, or removes from Trinidad and Tobago that criminal property, commits an offense of money laundering. Alright, so, and 2, that's 45.1. 45.2 of the Act says, for the purposes of subsection 1, a financial institution or listed business knows or has grounds to suspect that the property is criminal property if it or he fails to take a reasonable step to implement or apply proceeds to control or combat money laundering in accordance with the regulations made pursuant to section 56. Right, so for the purposes of subsection 1, a financial institution or listed business knows or has grounds to suspect that the property is criminal property if it or he fails to take reasonable steps to implement or apply procedure to control or combat money laundering. So the position is, if you don't have safeguards in your organization, then if you are one of the listed businesses, meaning listed under the Act as businesses that must be registered with the financial institution, the FIU, right? Then you're going to find yourself under the presumption that you are involved in money laundering if you don't have proper safeguards and proceeds come to you from crime. And it'll be your burden now to discharge the fact that no, we weren't money laundering, we just didn't have proper safeguards. But you will take your licks when you get it for not putting the safeguards in place. So that's one of the challenges we're dealing with now. Compliance.
So,
compliance. Oh, that brings me to the story about the Range Rover the other day.
Oh yes.
You
understand?
That guy's images was on social media.
Well, I understood he took the picture, I guess, and put it up. Calvin bought his new Range Rover or whatever.
Put it up.
Proud moment.
Well, I got that impression. I could be wrong. But what I was curious to me was the shape that the debate took. I don't know if I missed this portion of the debate, but many people were arguing about whether he was involved in criminal activity or not. I can't speculate. I know these are fishermen, they say. Hey, I don't know. But what's interesting to me is that the people who dealt with him had a right to know. So the people who dealt with him should have generated.
Who sold the
That's
vehicle?
right.
It is standard now, requested by
Standard
Central
practice.
Bank.
You go into the bank with $10,000 and they want to know, well, who's your mother,
You have
granny,
to
uncle,
declare.
nephew,
You have
cousin.
to declare. You have to declare.
Right, and they want to know where neighbor Stringberry and if he cast to do, so they're making sure you stay in Trinidad. They want to know everything. So my thinking is, which is what the law requires, there should have been a proceeds of funds transaction.
Right.
So he should have generally be able to say, these are the proceeds, this is where the proceeds of
Write
funds
a
came
check
from.
or something.
Right, and be able to say, all right, this is where the funds came from. And after the proceeds of the oh gosh, what did I just tell you? Anyway, moving on.
Yeah.
If they're not satisfied with where the alleged source of funds document, if they're not satisfied with the content of the source of funds document, then the seller of the vehicle can generate what they call a STR, a suspicious transaction report.
Right, and they could file that.
And that is usually forwarded to the FIU for FIU to do their investigation. So I don't know what happened, but it would be curious if FIU didn't get a STR from them. Understand? On a cash transaction for a Range Rover from someone who's 26 years old.
Cash?
I don't know. I don't know what the circumstances are. If, quite frankly, it was a legitimate check from the bank and or even a finance operation, hey, it's in the bank already. At best, they will still generate a source of funds.
Source of funds,
right?
yes.
But your funds are now legitimized through the bank. So at the end of the day, you could say, listen, savings or whatever.
Yeah,
from
but
the
it
bank,
came from
and it's legitimate.
whatever.
However, if the man walk in there with cash and say, listen, I have cash in my account to pay this, or I have cash in my hand to pay this,
That's something different.
then that's a different story.
Yeah, correct.
And I'll tell you straight out, on a personal experience, I've had a client who's paid for his Range Rover in cash in 2 parts, and it was accepted.
Yeah.
Right? I didn't go behind the curtain to find out whether a STR was generated, a suspicious transaction report was generated.
Yeah, because I went to a particular company that sells Mercedes Benz. All right, and they wanted the source of funds.
Yeah.
They wanted a source of funds, especially when you're a self-employed person.
That's right.
Like
if you're
me.
self-employed, you have to generate it. So, but in fact, anyone's supposed to produce a source of funds generally, and if you're self-employed, it's even more. It's a
it's like it's like so much a question.
Let's say you're working in the bank with $10,000 and up, they want to know where they're in able string.
They want to know.
So, as I said, I would expect that if he passed these tests, hey, you can't fault.
Can't fault the brother,
right?
You know.
So the question was, were the safeguards in place? I didn't hear that part of the debate. Now I could be wrong. People could have been talking about this en masse, but I didn't hear that part of the debate. And I was concerned that, to me, that is where much of the debate should have been.
Yeah, that is where the answers are.
That's where the answers are. So forget his means and whether he got his money
he got his money. Stop assuming, because all you have to do is to get that source of funds document.
That's right. If you follow the process, then
that's all. So just maybe there weren't any legitimate source of
and maybe it's all legitimate,
you know.
Well, so we don't know.
Diana says, sadly, corruption has anchored its roots on the soil of TNT. The stressful effects of this tumor have engulfed the merit and talent of our country. It may include many activities like bribery, theft, fraud, extortion, blackmailing, abuse of discretion, clientelism, favoritism, nepotism, and embezzlement. No matter overt and obvious its consequences are for society, corruption is a crime that prefers to remain covert and concealed. It can take roots in many areas of a society, whether in government, law enforcement agencies, or among other actors such as media, business, political parties, and so on.
My
she gave
God.
us a paragraph.
That's right.
Yeah, I talked to you about Diana yesterday. You feel it's joking.
At that rate, she needs to write a book. Needs to set it out. No, sometimes we talk about these things, but we need people to sit down. Listen, one of our biggest problems in Trinidad, as far as I'm concerned, we don't have enough academics. We don't have people who, after they've finished a full career, dedicate the time to sitting down and writing about what they've experienced and how it impacts our society and how it should work. I'm fed up hearing judges complain about not having enough income after they come off the bench, because after they come off the bench for 10 years, they can't practice as attorneys anymore. You've taken away their livelihood.
Right, for 10 years.
So nobody really is excited about becoming a judge, because at the end of that process, you may find yourself, understand, less well off than when you started. Okay. Because by the end of that process, you're basically in retirement. And you can't go back to the practice. That's right. And you can't go back to the profession that you practice. So you now have to live on your retirement.
Right.
And that is where you have to transition to becoming an academic.
Yeah.
And I would expect that is where we should be getting the proliferation of our books and writings and whatnot.
Correct.
I shouldn't have to pick up a Smith and Hogan criminal law textbook from England anymore. I shouldn't have to pick up a Barnett administrative law textbook from
case studies.
We have enough case studies in the Caribbean. We have a whole new Caribbean Court of Justice. We need our people who have done the work and had the experience and have the academic qualification now to sit down and write. So Diana, is it Diana?
Yes, Diana.
So
right. People need to begin to write.
What is the incentive for that? Do they? Is it that if they do that, they could make money selling?
Yeah, but there's a market. At the end of the day, if someone were to compile, and you have to realize,
just a book of case studies.
That's right. Local, because the challenge is local authorities are difficult to come by. When I say difficult to come by, local academic authorities. I could go to the judiciary's website and I could pull up case law on different points of law. As for someone sitting down and putting together the law as we see it from a Trinidadian and a Caribbean perspective, we need more of that. That's what Dana Sita had started to do. She started writing her books.
Wow.
Right? Wow. We lost her. And she put together a very composed criminal textbook. Right?
Okay.
Criminal procedure textbook. I mean, and she was continuing to build on that. We need more people to do that. And there are people out there. Look, we had and this is just to name a few because there are many others, but we need more. Because I've found recently it's a dying art. You're not finding people willing to go in that direction.
And right, yeah.
And so there is a market for it. It will sell locally, it will sell in the Caribbean. It will sell outside of the Caribbean because there are other people who are interested in our
wants to understand the judicial system.
That's right.
Should they get involved?
Who are involved in enhancing jurisprudence. Okay. So people are always interested in hearing it. So there is a market. It may not be the giant size market you'd want for, understand, to be
that's a release a book.
You understand?
But it has purpose.
It may not be on the New York Times bestseller list. That's right. It may not be on the New York Times.